Hello everyone, today I'd like to discuss you about the recent developments in relation to the judgment of the Honorable Supreme Court in May 2025, which mandates the 3-year practice as an advocate is essential to appear in judicial service examination. First of all, I'd like to tell you about the brief chronology of event which substantiated the hypothesis that the Honorable Supreme Court is consistently inconsistent on this particular issue. In 1992, the settled position is that the Honorable Supreme Court endorsed the view of All India Judicial Service examination and allowed the fresh law graduates to compete in the examination. Now, after this judgment in 1993, the review petition is filed, and in review petition, mandatory requirement of 3-year practice was made essential to appear in judicial services examination. After this judgment, to assess the situation, Shetty Commission was appointed in 1996. The Shetty Commission recommended that we are not able to get the best talent due to this 3-year practice rule. Hence, in 2002, the Supreme Court again scrapped this rule and allowed the fresh law graduates to appear and compete in the examination. Now, in 2025, again, the Honorable Supreme Court, on the basis of views of various state governments and affidavit of various high courts, thinks that the 3-year practice will be more useful and again restored this particular criteria. Now, what happened after this decision is that there is a lot of uncertainty and confusion among the fresh law graduates. Now I will tell you why this judgment is having errors apparent on the face of the record. Because the decision was not on the basis of any empirical evidence, quantifiable and comprehensive data. The decision was just on the basis of affidavit filed by the various high courts. In that also, 4 or 5 high courts reserved their opinion in favor of fresh law graduates like Punjab and Haryana High Court, High Court of Tripura, Nagaland, Chhattisgarh. They supported the views of fresh law graduates, but that was not taken into consideration. Also, the next point is that it will fail to attract the fresh meritorious candidates because it will create a 3-year vacuum. It will disproportionately favors those who are having a legal background and those who don't have a legal background. And also those who belongs to economically weaker sections and socially disadvantaged communities, they are not having any time to wait because they cannot wait for 3 years due to financial constraints. It will be difficult for them to complete the 3-year practice requirement. The rule looks fair and neutral on its face, but it indirectly putting our women candidates in a very disadvantageous position because the societal and family pressure which they will handle, it will be very difficult for them to complete the 3-year practice. Because the situation of male candidates and female candidates are a little different in our country. So this requires a serious introspection. Otherwise, if we compare about the current data, almost around more than 50% of judges are female candidates. and they are meritorious. In all the judiciaries, they are among the top rankers. So if we bring this criteria, we'll unable to get a best talent, which is quite visible on its face. Now, the good thing is that the Honorable Supreme Court again accepted the review petition, and in a recent hearing, they acknowledged all this, that it is a challenging task with this rule to get a fresh talent. So I have very high expectations with the Honorable Supreme Court of India, and I have a greatest respect to the Honorable Supreme Court of India, and I think that the Honorable Supreme Court will definitely give its judgment in favor of fresh law graduates becoming examination. Thank you.